Good afternoon, everybody, and thank you for joining us for the second annual Attorneys General Forum at the SHOT Show. I'm very pleased that we have several distinguished guests with us today. From West Virginia, the newly elected J.B. McCuskey. From the great state of Kansas, Kris Kobach. From the state of Georgia, my good friend, Carr. The state of Montana, Knudsen. And from Missouri, the newly elected Andrew Bailey.
Ooh, brings it down.
Back to the audience.
He won. Fix. Call him Fix.
So, gentlemen, thanks again for being here with us. I look forward to having a lively discussion, and hopefully we'll be able to get some questions from the audience if time permits. But I want to start with probably what is the most important case facing the industry today, and I wanted to get your thoughts about the case, and that is the government of Mexico's lawsuit against the industry seeking $10 billion in damages, and importantly, not just damages, but wants a national injunction that would regulate the commerce of firearms in the United States despite federal law, despite what state law says, and is looking to basically have a court in this case, Boston, decide how guns can be sold throughout the United States. The case was dismissed. It went up on appeal, and it was dismissed on the basis of the Protection of Lawful Commerce and Arms Act. It went up on appeal to the First Circuit, and many, if not all, Republican AGs signed an amicus brief. Not surprisingly, most of the Democrat AGs signed an amicus brief on the other side supporting the government of Mexico's lawsuit. And the First Circuit reversed and remanded the case to the district court. The United States Supreme Court granted cert. It's been fully briefed and now will be argued on March 4th. And so I want to, and again, thank you, because every single Republican AG signed on to the amicus brief, which is a really strong statement. But I want to get your sense about why you think the case is important and what the danger of the case is, not just to the industry, but to the rule of law in general. And Austin, since you led that brief, I'll let you begin.
All right, I guess I get to face the firing party first. Thanks all for being here. Yeah, so Montana, we led that amicus effort, and that was an easy one for us. I mean, I'm a gun guy. So, I mean, you have, what's stunning to me about this case is a couple of things. I mean, first of all, you've got a foreign government trying to avail itself of America's federal court system. That in and of itself is pretty stunning. But the fact that Mexico is going to come into our federal courts and with a straight face argue that, yeah, the reason they've got so much violence in Mexico is because of American gun manufacturers. It's not the cartel violence. It's not the fact they've got a completely disarmed populace. It's not the fact that their government is corrupt from the top to the bottom. No, it's American manufacturing that's the real problem here. So, I mean, I just take offense to that. But, I mean, this is a really, really important case. I mean, this is Katie bar the door. If we let Mexico come in here and bring a case like this, and this case is allowed to proceed, this is very dangerous. This was clearly what the framers of the PLCAA meant. I mean, this is precisely the kind of frivolous lawsuit that legislation was passed, clear back during George W. Bush's days, to prohibit. So, I mean, the fact that the appeals court flipped that around, I think is pretty stunning. But look, the fact that the U.S. Supreme Court not only took the case, but now they're going to do oral arguments, I think that's a very, very good sign. I think we're in a really good position in this case, and I think they're going to do the right thing here.
It is the first time the Supreme Court has taken a case involving the PLCAA, so we'll see what they say on that. Kris, your thoughts on the case?
Yeah, I think it's absolutely laughable that Mexico would come to, as Austin said, in our court system and blame us for the problems they have with the cartels. But look, it's the same theory, though, that we're seeing in a lot of jurisdictions around the country. You know, instead of going after criminals, go after companies that make a legal product that in the United States are intended for law-abiding citizens to defend themselves, their family, and their property. This is the same theory. It's also a little bit public nuisance on steroids. I don't think anybody ever thought, contemplated, or considered that a foreign country would come into the United States of America and do this. It is dangerous. I cannot imagine for the life of me. As Austin said, I think it's probably positive that the court's going to take this and just and do away with it. But this is the dangerous underpinning of using the legal system. When take Mexico out, you can put in any a lot of jurisdictions around the country. You can't get it done in Congress. You can't get it done in your local legislature. Weaponize your state AG or go to the civil justice system and try to get something done that you couldn't get done legislatively. It undermines the American experiment, and it's dangerous.
Yeah, I would completely agree. And Kris?
Elder Kris. Yeah, I am, to give a bit of confidence here, I'm not worried at all. The U.S. Supreme Court is a court of textualists now. All of the 6 more conservative justices will stick to the text of the PLCAA. I think the text of the act is clear on this one. They're really trying to stretch the words, and even some of the liberal justices may come around on this one. So I don't have any doubt that we're going to win this one. I mean, I hate to be that confident, but I just really am confident. I'll disagree with one thing Austin said. He said this is exactly what the drafters of they were afraid of, the PLCAA. No, I think they were afraid of the somewhat crazy lawsuits brought by left-wing cities and left-wing interest groups. I don't think they even dreamed that a foreign country, I mean, this is like ultra crazy. Yeah. But I think it's clearly prohibited by the federal statute.
Well, there's an interesting wrinkle to why it's like public nuisance on steroid. And the reason is the lawyer representing Mexico is a gentleman by the name of Jonathan Lowy, who for decades was with the Brady Center. It was their chief litigation counsel and the architect of the lawsuits, the municipal lawsuits against the industry. So he's just taken his shtick on the road, frankly. But if Mexico prevails, it is literally Katie barred the door, because every other country could file a lawsuit against the industry and completely bankrupt the industry just from having to defend the lawsuits. Forget about their utter lack of merit. So, meanwhile, you know, as you mentioned, Austin, Mexico is completely corrupt. They don't stop at any of the cartels. The cartels control most of the country. So it's very interesting to see President Trump sign an executive order that he's ordered the new Secretary of State Rubio to evaluate whether to declare the cartels foreign terrorist organizations. So that would be a game changer in that dimension as well. So I want to give JB and Andrew an opportunity to weigh in, even though you weren't on the brief, but I'm sure it's important to your states as well.
Sure, would have been happy to be had I been there. And I got to follow Patrick Morrissey, which is just a real champion for the Second Amendment. And, you know, when you live where we live, you know, firearms are a way of life. And I would be really interested to see what Mexico's thoughts would be if we sued them for all the damage that illegal immigration has caused in the United States. So, you know, you kind of got to be careful what you wish for in this instance. But it is such an obviously bogus lawsuit. It's so obviously, I agree with Kris. I'm not worried at all. You know, we have justices on our Supreme Court for the first time in my life that as a group read the language of our Constitution and of our laws in the way that they were intended to be read. And so, you know, I think this is actually in some ways a really great opportunity for us to say, you know, this is absolute hornswoggle, and
if that makes it into the opinion, you get credit.
That's a legal term.
Who had that on their SHOT Show bingo card?
That's a legal term.
that's some grade A Appalachian gibberish right there. You guys can take that home.
That's Latin.
But states are going to do this too, right? And so what you have now is 29 Republican attorney generals. It's the most I believe we've ever had. And so our group is bigger and stronger and smarter and better than their group. And so I feel really, really good about where we are, especially on this issue and in that case in particular.
Yeah, I think that it's important, and I think that my colleagues and I have been united on this issue and so many others like this, and to adapt to the evolving battlefield. It was easy over the past 4 years to point to Joe Biden and Kamala Harris and say, that ain't right, that's not constitutional, that's not legal, and to file numerous lawsuits against them. You know, we've been leading the way on so many different issues to restore the balance of power between the federal government and the states being, repositories of residual authority that was not ever granted nor intended to be granted to the federal government. And I know my colleagues agree with me that, we view the Constitution as, the rights enumerated therein come from God, not man, and it's a document designed to protect us from the government, and it was never intended to allow for a foreign government to infringe upon those God-given rights and to abuse our judicial processes. And so this is important, evolving to the adapting battlefield, and now that Biden and Harris are out of office, those progressive radicals that want to take our right to keep and bear arms away from us will go from the cubicles in Washington, D.C. to progressive cities and states across the country, and we'll just have to remain vigilant and adapt to that evolving battlefield and fighting off litigation like this and so many progressive cities and states that are going to cobble together coalitions to attempt to infringe upon those rights. We'll have to stay vigilant.
No question about it. So I want to just stay with the Supreme Court for a minute, because while I share your optimism about the outcome of the case with Mexico, I am scratching my head at times as to why the Supreme Court has not yet granted cert in a hardware case. And many, many petitions have been presented to the court, often in preliminary injunction stages. So I can understand that, but there are, as you well know, because you have been submitting amicus briefs in these cases, the circuit courts are just defying the Supreme Court. And it's open, it's blatant, in my opinion. And we saw in a denial of cert concurrence by Justice Thomas and Alito, as well as Gorsuch, in the case out of Hawaii, where it was the Spirit of Aloha case. And NSSF's involved in a challenge to the Illinois statute. It went up on preliminary injunction where the Seventh Circuit reversed the grant that we had obtained. We argued that, now's the time. Why are you letting them do this? They didn't take the case, sent it back. We won at trial. We've got a permanent injunction. It's now in the Seventh Circuit. It's been there for a while. They have yet to set a briefing schedule. But there are two cases that are pending cert petitions before the court. One is out of the Fourth Circuit, the Snopes case, which is after trial. And it's one of the most ridiculous decisions I think we've ever seen on Second Amendment analysis. And a case out of the First Circuit, Ocean State Tactical, involving a magazine ban challenge with a terrible decision as well. That's at the preliminary stage. The court has, conferenced it and not decided many, many times. They kicked the can down the road again. And there's a lot of growing concern that the court is, why are they waiting for? Why they've got Snopes as after trial. Why wait? Why won't you take this case? And I'm wondering what your thoughts are about why the court has yet to grant cert, because it seems so obvious that these decisions are not applying Heller and the Bruin test faithfully, and not even close. So I'll start with you.
I'm going to do the politician thing and answer a different question. You're
Wait,
right.
we can do that?
Yeah. You're right, and I take a semantic view, originalist view of the Constitution, which I think that Justice Thomas and Alito and so many of the other conservative justices do, which would mean you look at what constituted an armament in at the time. Obviously in Missouri we have Article 1, Section 23 of the Missouri Constitution that explicitly, textually says the state shall, defend an individual's right to keep and bear firearms, ammunition, and accessories. I think the United States Supreme Court will get there. Certainly that is what my reading of Heller and its progeny. I'm proud to announce that as of tomorrow, I'm going to file a petition for writ of cert at the United States Supreme Court on Missouri's Second Amendment Preservation Act. And this is an interesting vehicle to address a lot of these questions, because it's as much of a 10th Amendment issue as it is a Second Amendment issue. And as everyone will recall, the 10th Amendment says that any authority not given to the federal government or denied to the states is enjoyed by the states and the people of the states. And so the state of Missouri, through its elected representatives in our General Assembly and signed into law by our governor, enacted a statute that says that we will not allow the federal government to coerce and commandeer the apparatus of state government to accomplish unconstitutional gun restrictions, unconstitutional restrictions on ammunition, unconstitutional restrictions on accessories. And so, yeah, thank you. I'm excited to file that petition for writ of cert at the United States Supreme Court tomorrow, and I think that's going to be a unique vehicle to address, kind of like if you remember the Dobbs decision and how it overturned Roe, the question starts narrowly, and the question we're posing to the court is, does the federal government have standing to sue the states over laws that they don't like when they're not actually impeded by these state statutes? But if we get cert, I think that it expands the range of issues that can be litigated at the Supreme Court on that case. So I'm excited to get that on file tomorrow.
Oh, good luck. Be looking forward to reading that cert petition. So, Kris.
Well,
First, Kris.
There's no possible way I'm going to analyze the law like Andrew just did, so I'm not even going to I'm not even going to give that a shot. Here's what I think, Larry. You and I were talking about this backstage, and what's the court waiting for? I don't know, but I do think you're on to something when you talked about the circuit split. And here's one thing I think that's important. During the Trump years, the criteria for appointing judges was based on philosophy, conservative, textualist, intellect. Yeah. What I saw over the last 4 years is, are you an activist? And so I do think that the court may be waiting for now one of these, what's become activist circuits, and we know which ones that they are, to do something that allows them to take it up. Because I don't know. I don't know the answer to the question. But I do think the philosophy has changed so much in a way that I think is dangerous. And again, one of the great things that came out of the first Trump administration were the judges, and thank heaven. But you've seen around the country, there's been a lot of changes philosophically. And are you an activist, I think, is one of them.
So I don't think there's any nefarious or unusual motivation in the court not taking the case. Over the course of my career doing various complex civil litigation cases, there's so many times where we had a circuit split, important question, and we didn't get cert. It just happens over and over again. Here we don't yet have a circuit split among final decisions. I think when we get that circuit split, maybe after the Seventh Circuit rules on final action, then they'll probably take it. But I think the earlier part of your question is really interesting, and that is to give a little context to folks who don't know about the Bruen case. The Bruen case a couple years ago was an earthquake in constitutional law, because prior to Bruen, the Second Amendment was the redheaded stepchild of constitutional rights. Oh, yeah. Well, like him. And so
We'll beat you backstage.
So after Bruen, the Second Amendment went from below the others to not just equal to the other rights, but actually superior. The test for the Second Amendment now is this historical analog test. There's no balancing of government compelling interest. In order to prevail against in order to show that some new regulation can stand against the Second Amendment, you have to show there's a historical analog from the founding period that is sufficiently like the new regulation you liberal litigant are trying to defend. It's very difficult, and I think the circuit judges, a lot of them that are left-leaning, they're just absolutely horrified by this new test that gives the Second Amendment this privileged position. And so you're right, they absolutely are trying to find ways to chip away at it. And I think the Supreme Court will, they see the Bruen test being eroded, and they are going to have to step in. Now, I'm confident about 4 or 5 justices of our Supreme Court that will keep it robust. But as you know, in the Rahimi decision, the Supreme Court did allow the Bruen test. Well, they applied the Bruen test, but they found that in this case, the law, if you had a restraining order against you, you could be disarmed, and they found some historical analogs that weren't really historical analogs. So the test can be manipulated, but it's really strong, and I think that's why the circuit judges are bracing, they're recoiling against it.
Yeah, I mean, well, one of the concerns we have is that if the court doesn't grant cert, that just will encourage more misbehavior. And we're staring additional hardware bans in Colorado. That could move very quickly. Rhode Island now. in other states, and so it just keeps, kind of growing on itself. There is the possibility of a split because there's a challenge to the Delaware assault weapons that will go back. It was up to the Third Circuit once and sent back down because of at a preliminary injunction stage. So that will eventually make its way back to the Third Circuit. Hopefully, that would result in a split if that's what, in fact, they're waiting for. But if they're listening, you don't have to wait.
Yeah, that's right.
And they're certainly not listening to me. So another topic that is of concern to the industry, and this kind of ties in with the Loper decision, is we see a lot of rules promulgated by ATF lately, or policy positions, where they're overreaching with the regulation, far exceeding the statutory language. We saw that with the bump stock rule that the Supreme Court has addressed. There's the arm brace rule. Now there's litigation involving, and the arm brace rule is before the Supreme Court. We're waiting on that. But then there's the engage in the business rule more recently, which completely, in our opinion, exceeds the statutory authority. It's been enjoined, and that litigation goes on. But what's troubling and was discussed in a lot of like the bump stock and the arm brace litigation is the federal agencies, in this case ATF, using regulations to create criminal statutes, essentially criminal law that's not provided by Congress. I'm wondering what your thoughts are on that pattern of behavior and the dangerousness of that to our freedoms.
Yeah, so we did the EPA case in West Virginia, and this is a sort of topic not important, right? The federal government has done this because Congress has refused to act. And it's really amongst all of the reasons why it's so cool to be an attorney general, but we have sort of become as a group the de facto hedge against what the Congress allows the bureaucracy to do. Right, in West Virginia, we mine coal, and the EPA decided that we weren't going to be allowed to do that anymore through rule, not through statute. There was no debate, there was no transparency, there's no accountability, and they far exceeded their role and their constitutional scope in sort of dictating how and what our state could be doing to run our economy. And this is absolutely no different, right? This is the bureaucracy fills a void that our Congress does not fill. And the most important people in that world now become the attorney generals, because we are the only ones who can swiftly and quickly challenge what the bureaucracy is doing. It should be Congress, but it isn't. And so in this world, the people on this stage and the other 24 Republican attorney generals in this country are the people who are going to step in and say to the bureaucracy, this is well beyond what you're allowed to do, both constitutionally and legally. And we can actually wipe statutes off the book, which is actually the most. When was the last time Congress didn't add to the end of a statute, right? When they fix a problem, they add language instead of remove it. And we have the unique ability to enter jurisdictions that we don't exist in, challenge laws both by states and by the federal government, and actually remove the cancerous language as opposed to just add to it, which I think is really, really important. And, the Second Amendment, to get back to your earlier question, I think sometimes the Supreme Court thinks that they have solved a problem, right? And so when they decided Braun, my gut tells me that most of them are like, okay, we've got our Second Amendment case done. We fixed it. And so then it gets put down on the bottom of the pile on a bunch of other things. And, I think one of the things that this industry needs to do a better job of is explaining the economic impact as well. It's not just about the right, it's also about the millions of people that work in the industry and the billions of dollars it creates. And, I think people don't understand the largesse of what the firearms industry means beyond simply advocating for the Second Amendment.
Yeah, I worked in the Senate for 10 years. And, somewhere probably around 2008, 9, or 10, Congress stopped doing the things it was supposed to do, to what JB was just talking about. And nature abhors a vacuum. In D.C., that vacuum, if Congress isn't doing it, it's going to get filled by the federal executive through regulation and executive order. And we've just seen this snowball effect. But what we saw, and again, if Congress doesn't push back in our federal system, there's only one place to do it, the states, which what JB was just saying is that we are the last line of defense. What is troubling to me about there's a lot of things troubling about the previous administration, but one of the things is they were filled with activists who never even attempted to go to Congress to do it the right way. That's true. And when you have activists, they're going to keep pushing it. These political appointees are going to keep pushing it farther and farther. They knew they weren't going to win. And what, again, bothers me and undermines the American system is they were trying to push this further and farther simply for political points. So, again, there are things in this country we need Congress to do. And we need Congress to act. And I am very hopeful, particularly now that we've got the keys to all three cars, the White House, the Senate, and the House, that we can do some of the things that we need to shore up. Because, again, there is just a fundamental difference out there. You either believe that the Second Amendment is equal to all the other Bill of Rights, or you don't. You either believe that this is a legal product made to defend law-abiding citizens, their families, and their property, or you don't. And what has happened is we continue to see activists going at it, trying to chip away at it, and they've had partners in the federal government. So again, there are things Congress needs to do. We need them to go back, and we need them to be able to shore up some of the things that we believe in and that we think are important as it relates to self-defense.
Kris?
Yeah, I want to speak to the latest of the examples you gave of ATF just completely twisting language. You know about the bump stock rule where they're trying to redefine what it is to be a machine gun, what a machine gun is. The latest one, which is the engaged in the business rule. How many of you guys have heard of that? Okay, this one is really pernicious. Kansas led a case, and all 5 of these states are on that suit, and then there's a companion case that Texas led of Fifth Circuit states. And basically what the ATF did is said that you need to be have an FFL, and you need to do background checks on garden variety transactions between 2 friends who just want to trade a gun, or I bought a gun and I don't really want it anymore and I'm going to sell it to you. And they twisted the words in such a blatant and ridiculous way. Engaged in the business of selling firearms in statute says that there are repetitive transactions buying and selling. It's a gun store. It's someone who's in the business, their livelihood is in guns. They said, well, 1 transaction is enough. No, that's not what the statute says. Then the other thing they did was even more pernicious. Federal law says that there's an exception, a safe harbor. Anybody can sell from their personal collection, make occasional sales from their personal collection of firearms, and you're not going to be considered an FFL. Well, what did ATF do? They said that guns obtained for personal protection cannot be part of your personal collection. Now just think about that. A gun used for personal protection cannot be considered part of your personal collection of guns. Well, last time I checked, every functioning gun is used for personal protection, right? And so they've said that there's nothing in that safe harbor anymore. Again, a weird twisting of the language. I think we're going to win in both of those cases. The Texas case is in front of the Fifth Circuit. The Kansas case is in front of the 10th Circuit. If the case is not mooted out, I'll be arguing that in March. But I hope we do actually get to win in one of those 2 circuits, because this is the kind of pernicious twisting of language that will happen again in a future Democratic administration unless we get at least a Court of Appeals decision saying that was a ridiculous twisting of language. So this is what we're up against.
And I call it legal gymnastics.
Yeah.
Go through these legal gymnastics. And my friend Marty Daniels in the back. We have Savannah, Georgia. Savannah, Georgia passed an ordinance saying that you could not keep a gun in an unlocked vehicle. And they said they were regulating the car. The gymnastics, again, the lengths that they will go to, because they fundamentally hate guns. And they fundamentally don't believe in going after criminals versus defending the rights of a law-abiding citizen to defend himself. Yeah. That's the gymnastics that we're seeing.
Austin?
I just want to make a really quick, an actual boots on the ground logistical point about this, Larry, which is, you folks need to understand, this is a difficult job keeping up with this garbage. Now, we're lucky that we've got friends in the NSSF and our friends with the NRA. They pay attention to the Second Amendment stuff when there's a dark of the night new rule promulgated by ATF after they've promised, left hand on the Bible, right hand, fingers crossed behind their back, they're not going to redefine this rule, and then, oops, yeah, I know we did it. That's fine, but I literally had to employ full-time staff in my office just to watch the Federal Register and see what other kind of crazy rule that EPA or Department of Energy, I mean, go down the list, just crazy stuff they're pushing out. I mean, it was daily there towards the end before Joe Biden got out. They were trying to shove so much stuff through. No notice, no comment, we don't care. And this is to Kris's point. I mean, this is just pure partisan theater and trying to score points. Like, we understand that, but it doesn't change the fact that it takes a lot of eyes and a lot of effort for our collective offices to keep an eye on this stuff and to be able to react the way we do. I mean, which is why groups like the Republican AGs Association are really, really important and helpful. And the fact that we all get along. I mean, we're rowing in the same direction, and we're able to spread that work out. But I'm here to tell you, it is a full-time job. It was a full-time job keeping an eye on the Biden administration.
Yeah, get rid of the ATF. Why do we have that at all? Like, why are we paying for the government to deprive us of our rights? The government exists to protect our rights. The Constitution exists to protect us from the government. Like, the whole thing has been perverted, our founding fathers are rolling over in their graves. Get rid of the ATF. You know, we talk about these rules exceeding the scope of the statutory authority of the statutes to create the agency and granted authority. Well, there's no sanction in the United States Constitution for a fourth branch of government that's unaccounted to the electorate.
Well, that's, I think, one of the reasons why the Looper fisherman case was so important. Going back to your point about Congress not doing its job, this is going to kind of force Congress to have to do its job because the regulatory agencies are, going to be reined in from like just creating law because and we saw it just last week. We submitted a letter to the FBI on their rule to implement a provision in the Bipartisan Safer Communities Act to allow licensees to run employment screening checks. And they tried to restrict in the rule who could be subject of a check. And we said, there's nothing in the statute that says that. It says employees. It doesn't say certain employees, or it doesn't say employees who do X, Y, and Z. It says employees. Employees means employees. You can't make policy that way. That's for Congress to do. So, but I think the death of Chevron will, I think, help restore freedom and rein in the fourth branch of government, the administrative state.
It will, but it's not self-enforcing, to your
That's
point.
correct.
I mean, that's the problem. Like, we all celebrated the overturn of Chevron and, West Virginia leading the way, and West Virginia v. EPA kind of reinvigorating the major questions doctrine that was then reaffirmed in our suit, Missouri and Nebraska suit against the Biden administration on the student loan bailouts. And then the very next term, you see Chevron overturned. And so you see this, like, growth in restoration of the separation of powers. And so what's next? Can we find a vehicle to reinvigorate the non-delegation doctrine? And I think that's hopefully on the horizon, and again, to restore the proper constitutional order. But to Austin's point, Chevron is great, and we all celebrated it being overturned. But at the end of the day, it's not self-enforcing. We still have to file the lawsuits.
Well, and the Republican AGs have been, at the tip of the spear in these challenges, so we really appreciate that.
But Larry, we appreciate the private partnerships and the partnerships of groups.
Absolutely.
Like you, again, bring it to our attention so we can do it together.
So I just want to turn to another area and just that we see as a potentially troubling trend, and it's not entirely new, but many states have state preemption laws that prevent local cities, municipalities, et cetera, from regulating firearms. And we see increasingly new rules or regulations being adopted in states that have state preemption. We see it in Ohio on a regular basis. We see it in Pennsylvania on a regular basis. And A.G. Bailey, you just dealt with this in Jackson County. You want to talk about that experience?
Yeah, absolutely. And we see it in we're bookended by our two largest cities in Missouri, Kansas City, most of which is on the Missouri side. Some of it's on the Kansas side, but most of it's on the Missouri side. St. Louis is on the Missouri side, a little bit in Blue, Illinois, but those are very progressive cities, and they have impulses that are not aligned with our values and not aligned with the other 114 counties in the state of Missouri. And so Article 1, Section 23 of the Missouri Constitution explicitly codifies the preemption doctrine that municipalities are not allowed to infringe upon our right to keep and bear arms, ammunition, accessories. And it creates both a moral and a legal obligation of the state of Missouri to enforce that right against those municipalities. So we have and will continue to file suits against both St. Louis and Kansas City when they try to infringe upon our right to keep and bear arms. I think that, and again, when we talk about the repeal of Chevron's not self-enforcing, it's the same thing here. It doesn't help the average citizen who is prosecuted for having a firearm in their vehicle in violation of some municipal ordinance. As the state, I can come in and eventually get that overturned, but that individual still suffers through years of litigation. And so in Missouri, I know there's a bill that we've introduced in our General Assembly that I'm supportive of and helping to push, which creates a private cause of action.
Well, that was my next question, is how do you hold these municipalities accountable
You
when they
sue them
violate
and
the law?
collect damages.
And can get attorney's fees?
Absolutely. Yeah, that's the best way to do it. That's the best disincentive to bad behavior.
So that similar bill is moving through our state legislature. It's a top priority for the various firearms, pro-firearms groups in our state legislature. But yeah, same thing. I mean, you wrongfully infringe on someone's Second Amendment right as a municipality, you're not only going to get whacked with a civil case, you're going to pay attorney's fees.
Because you see this even like, in red states, right? There's always, a liberal city or an.
There's always the blueberry and the tomato soup.
So it's, and Kris, you experienced this too, as I recall. You've had challenges to, preemption.
Yeah, it was the same thing. Again, like I said, the city of Savannah decided they were regulating cars rather than guns, and we went in, and again, we had a situation where we don't have the same authority as you do to go in there and sue, but what I did is I went ahead and I gave an opinion and made it public, so the defense attorney in that particular case has used it, and we'll see where now that in that particular case, it's gotten a little messed up at the trial court level on standing, but at the end of the day, they simply can't do it. We occupy the space. Municipalities can't regulate guns in Georgia.
Yeah. I want to switch to another topic. There's been a lot of chatter about this recently. The Biden administration set up this White House Office of Gun Violence Prevention and installed lobbyists from every town to work there, which is, I remember years ago when former president of the NRA jokingly said, if President Bush wins, we'll have an office in the White House, and the left lost its mind. But it was perfectly fine for them to install every town's chief federal lobbyist to work at the White House to advance anti-Second Amendment. The website's been taken down because the whole White House website was taken down. It's not clear whether the Trump administration has formally rescinded and shuttered that office. NSSF, I'm proud to say, was the first Second Amendment organization to call for the Trump administration to shut that office down. And I'll tell you why it mattered to us is because we saw that the White House and Everytown colluded to have Chicago bring a lawsuit against Glock, Inc., accusing them of being responsible for criminals who illegally obtained illegal switches and illegally installed them and illegally made quote-unquote machine guns. And, that lawsuit's been filed. It's still pending. Now we see additional lawsuits against Glock in this case, and it won't stop at Glock because what the bad guys do on their pistol design can be done on any striker-fired pistol. So that's an increasing problem. But one of the questions, it was investigated by House Oversight, but I wonder if there's a role for Republican state AGs now that a lot of your focus in the last 4 years was on suing the Biden administration. I don't imagine you're going to be suing the Trump administration very often, but can the state AGs bring investigations and look at collusion by Everytown and the White House and the former folks at the White House to trample upon Second Amendment rights, to damage companies like those based in Georgia or elsewhere? And another sort of tangent to that is, obviously, we are all aware that President Biden, on his way out the door, pardoned everybody in his criminal family.
Not from state-level offenses.
Well, that's my question.
Yeah.
Right? Also, they can't. They're called before Congress for hearings. They can't invoke the Fifth Amendment anymore. So, but is there a role for Republican AGs to investigate the conduct that went on with the Biden family, with the activities that were being investigated or tried to be investigated? I mean, DOJ may look at it as well, but is there a role for you all to take a look at some of this conduct?
Well, unlike Alvin Bragg, we don't invent crimes out of thin air. So you're going to find us more restrained in, I mean, we would do it, I'm speaking for myself, we would, if there were a clear violation of a state crime, then I don't think you'd see any hesitation among any of us up here to do it. But we're not going to invent crimes that don't exist. So in that particular case, yeah, this administration, the Biden administration, was notorious for communicating with private entities, so-called public interest groups, and trying to coordinate action, like what they did leaning on Twitter and trying to press all kinds of dissenting views during the COVID pandemic. So it's amazing as you see what happened and how pervasive it was. We Republicans we actually believe in the rule of law. So if there is if something eventually emerges as a crime committed, I don't think you'll see much hesitation from this group. But that's the thing.
You might get a little different answer state to state, only insofar as like what our respective authorities are. So like, for instance, in Montana, the Attorney General in our State Department of Justice has jurisdiction over nonprofits. And that is an area where I think we could see some Republican AGs look at some of these nonprofit organizations that also happen to be, virulently anti-2A. I mean, every town doesn't exactly swing a big stick in Montana, believe it or not. But they did try to run a candidate for governor.
Not very well.
That grenade blew up right in your face. But I mean, I think that might be one area that, depending on what your state authority is, I think you could see some investigation.
Well, there's another area, actually, I just thought of this, involving not-for-profits and fundraising. Are many of the animal rights organizations, like HSUS, that fundraises, and they make representations or insinuate how the money is spent, when we know, in fact, virtually none of the money goes to animal shelters, but they, pitch to people that you're going to help, the puppies and all that, and it's totally misleading and, in my opinion, fraudulent and potentially actionable by the states.
So two things. One, it is really interesting that they created an office to control gun violence, but simultaneously defunded the police. It seems like a much easier way to sort of try to thwart gun violence would be to ramp up your law enforcement to get criminals in jail, as opposed to wandering around with illegal guns. But what you're talking about on the fundraising side, that's just pure consumers, right? That is well within our wheelhouse, because at the end of the day, it's not any different than any other scam. And you just saw the other day where they were fundraising into Act Blue because of the California fires, right? I mean, that is just pure, in its most specific instance of consumer rights violations, right? And that is a simple way for us to manage these, what are huge problems, right? There's so much information and so many asks. Like, people get asked to give money to so many organizations, and we're all very hopeful that our side's organizations do a great job, and we think that they do, but it's so obvious that these other ones aren't. And we've already started looking into how do we find the right plaintiff? How do we find the right person in West Virginia who thought they were doing something with their money that they weren't? And where I come from, people don't have a lot of money, and $20 might be a big deal. That might be the gas for their car to get to work the next day or whatever it is. And so it's a huge problem. It really is.
JB makes a great point about defunding the police at the same time they were standing up this Office of Gun Violence, whatever it is. That's not insignificant. So our office, largely in Georgia, was civil until 2017. We got Domestic Terrorism Authority, 2019 human trafficking, 22 gangs, and then now 24 organized retail crime. And I say that because during the period of time, particularly 20 through 24, progressive DAs weren't doing the thing that government's supposed to do. Article 1, Section 1, Paragraph 2 of the Georgia Constitution says it's the paramount duty of government to protect person and property. They weren't going after violent criminals. They weren't going after street gangs. They weren't going after the cartels. So we've come in and we've done it. On the domestic terrorism side, because, again, the Biden administration just wouldn't participate, we've had to indict 61 Antifa terrorists for domestic terrorism and arson and RICO and other things as it relates to the Atlanta Public Safety Training Center. We've had to handle all the gang cases in Athens because the DA just was one of the, she just got beat, but she's one that decided she just didn't like the law. There's no gangs. She wasn't going to prosecute any gangs. We've indicted almost 20, 25 different gang members in Athens, Clark County. The point being, that is what we're supposed to do. That we are supposed to defend and protect the people of our states, and that going after those that are engaged in illegal activity, that's what we're supposed to do, and they ignored it.
Yeah, well, it's good to see many of these, soft on crime DAs losing, but they were all funded by George Soros. And George Soros was one of the major funders of lawsuits against the industry going back, in the 1990s, early 2000s. I mean, he was a major source of funding. So, and he got very sneaky. No one was sort of watching what was going on with these DAs races, and all of a sudden, people like Gascon and the guy in Philadelphia and Alvin Bragg. So when they're not prosecuting crimes, they're inventing crimes to go after their political opponents. So it's fortunately, I think we're seeing a change on that. But that wave of crime that took over the country starting in 2020 with BLM, I think ironically drove a lot of sales of firearms for personal protection because people were legitimately concerned for their safety. So.
Well, and take it a step further. I mean, they got their tails whipped this last election. I mean, turns out people actually care whether or not their hometown is safe.
Imagine that.
It is what you're supposed to do.
This just isn't
when you're
long
a
division.
prosecutor, you're supposed to prosecute.
Yeah.
It kind of goes with the job, doesn't it? So I just want to sort of have a general question, and you hear this term thrown around, and I think it's certainly applicable to what's going on with the industry with the lawsuits like we talked about the Glock case, for example, and others. Just the general concept of lawfare against legitimate businesses, certainly not just the firearms industry, but we're obviously included in that. How do you, as an industry or as a company, how do you fight back against lawfare? I mean, you can't shut down the courts, but how do we stop this? How do we combat it?
Yeah, I mean, I think it's tough. I think that at the end of the day, removing those Soros-backed prosecutors who pervert the law, we had one in the city of St. Louis who 96% non-prosecution rate. She wouldn't prosecute criminals, but she did prosecute the McCuskeys who held an AR-15 in an unthreatening manner just to keep the BLM and Antifa protesters from destroying their property. Was proud to draft the clemency paperwork to get them a pardon, and then ultimately filed the lawsuit to remove her from office, and we were successful in that endeavor. But at the end of the day, we've got to get creative. And I liked, my colleagues and I are completely aligned on this. It's like using consumer protection law, using antitrust law. That's an untapped fount of legal authority that we can use when you've got an insurance company that refuses to insure a firearms manufacturer, when you've got market manipulation against an ammunition manufacturer. And it's not only about protecting our Second Amendment rights, it's about protecting working Missouri families, working American families who are employed in this industry. And so we've been creative, we will continue to be creative, and there are these unique founts of legal authority that attorneys general have that we look to partner with members of your industry.
In Montana, it's interesting. You might not think this. I mean, you think Montana, you think very red, very conservative state. I'll tell you, we have got one of the most radical liberal judiciaries in the country. And so, to your point, Larry, when we've seen these cases, we've had to engage in fairly open warfare with our state judiciary.
You've experienced it personally.
That has not been comfortable on me nor my family. I was brought up on a 41-count legal ethics complaint because I said true but critical things about our state Supreme Court, and apparently I've impugned the integrity of the state Supreme Court, and that should make me lose my law license. But I mean, put that aside, there's an active effort afoot in Montana to really break kind of the liberal trial lawyers' monopoly on the judiciary in Montana. And I say that because we're a strange state. We elect all of our judges, from your local justice of the peace to your district judge, all the way up to our state Supreme Court. They are all elected. Well, under our state law, they are supposed to be nonpartisan. So that makes it extremely difficult to know who you're voting for. These are races that Montanans just don't know who these people are because they hide behind this veil of, oh, I can't talk about anything controversial because I'm nonpartisan, and I can't give you any idea of how I might rule in these cases. And so what ends up happening is the Trial Lawyers Association can put large sums of money behind their candidate and quickly get them elected. And Montanans are none the wiser because no one can find out about these judges. There's an active effort afoot in Montana to change how that's working. I think you're going to see judges start getting elected in Montana on a partisan ticket. Now, that might alarm some people, and I can tell you, they're partisan already. I mean, it's just time to bring them into the light. Every person on the bench with a black robe has political leanings. I don't think there's any problem with showing people what those leanings are, so you know what you're voting for. But I think in Montana, to your question, that's one of the ways that we're really going to attack the lawfare, because if these plaintiffs' lawyers and these trial lawyers know they can no longer go to their court buddies and more likely than not get the outcome they're looking for, I think you're going to see those cases start to dwindle down, at least on the state level.
We have an example of that type of lawfare going on in Kansas. It's in front of our state Supreme Court, and it's I think NSSF may have a brief in that too.
Johnson case against
Yeah,
Beretta and
Johnson,
Bass Pro Shops.
Yeah, Johnson versus Bass Pro Shops. So in that particular case, you have a plaintiff supported by these left-wing anti-gun entities. The facts are pretty straightforward. There are these two kids in a car, they're friends. One of them has a new gun. I think it's a Beretta 9mm APX maybe, and that gun allows you to fire when the magazine is removed, as do most guns, I think. He was trying to show his friend how fast he could disassemble it, and he was under the misimpression that he had to pull the trigger to remove the slide. And he just didn't read the directions for the gun. The gun functioned perfectly as it was intended to function, and when he pulled the trigger, it went bang, and he shot his friend in the leg. And that formed the basis for this lawsuit that the left is using to try to, again, attack the PLCAA and say, well, actually, that's a defect in the firearm. No, it's not a defect in the firearm. The firearm did exactly what's supposed to happen, and when you intentionally pull the trigger, it fired a round. But they're trying to say that, no, the PLCAA also means that if you didn't intend for a round to be fired, then the gun is defective. Now, that's not what the statute says, but if they actually got a very liberal panel of the Kansas Court of Appeals to agree with that absurd theory, they're going in front of the Kansas Supreme Court, which sadly, even though Kansas is a red state, we too have a very liberal, I would say second most liberal only to California Supreme Court because of the way we select justices. So the good guys may lose that case in the Kansas Supreme Court. Fortunately, since it involves the interpretation of a federal statute, it could be appealed to the Supreme Court. But we too are trying to change our method of judicial selection because the current system has produced such a left-wing state Supreme Court. And all too many of these cases end at the state Supreme Court because there's no federal question. And the left increasingly designs their cases, in Kansas anyway, so there is no federal question, so they can't be appealed to the U.S. Supreme Court. So we do fight, all of us are fighting in both federal and state jurisdictions. We're doing all that we can to protect Second Amendment rights, but the other side is devious, and they come up with very creative arguments, and at the end of the day, we just have to win.
Well, to your the point earlier about like manipulating the words of the statute, because it says, if the discharge the volitional act, and that was the proximate cause, and that Court of Appeals decision said, no, it has to be intentional.
Right.
As you say, that's not what the statute says. Well, just don't worry about what it actually says, because they're politically motivated to achieve a result. So,
right.
Yeah.
But Larry, I think it's Andrew kind of hit. This is a complex issue. You got to come at it politically. You got to come at it legally. You got to come at it legislatively. In Georgia, we got a big push. Our Governor Brian Kemp is pushing tort reform. I mean, that's also another way. Again, we the people decided that if we have a dispute, we're going to have the judiciary that we're going to go to. But the problem is the access to the judiciary is being abused by many. So lawsuit abuse. This is part of it. And you guys knew lawfare way before a lot of other people did in this industry.
Unfortunately, yes.
Unfortunately, you have. But it is going to take, again, electing the right people, getting some folks out, engaging in the process, engaging in politics, and not just, again, who the legislators are, who your judges are, who your district attorneys are, who your superior court judge, it all matters. But also legislatively, and I've said when governors make issues, it matters. So I think that's an important, I'm proud of our state and I'm proud of our governor for approaching this issue as well. Because lawsuit abuse, this is part of that. And but it's going to be a multifaceted approach to it as well.
So the one thing you have to do is fight, right? The only way you can stop lawfare is by being willing to take it all the way. And what I find in my private practice and what I found in the government is there's so many industries that feel like they're being abused and being taken advantage of, but when push comes to shove, they will eventually just say, all right, fine, I'm done. This is too expensive. I need to settle. It doesn't matter. It is so worth it to get to the end. And that is, it's a long, arduous, miserable road for anyone who's on the other side of one of these crap cases, right? But you have to take it all the way. And you got to be willing to put your name behind every single thing you say in every single one of those lawsuits. Because it costs them an enormous amount of money to lose. It costs them way more money to lose than it costs you to defend yourself.
We've got about 5 minutes left, folks, and I also want to be able to include any questions that you might have of the attorneys general. So are there any other questions that you might want to bring up? Hold on.
Thank you. In Virginia, we elect our judges through the legislature, and there's about 13 states that elect their judges in partisan elections. Is there any role for the attorney generals to inform judges of what Bruin says, what it says, how it should be understood, and how it should be implemented?
Well, like in Montana, the Attorney General has the authority to issue AG opinions. We don't do it very often. There's a process in statute where we have to be requested, hey, there's a question in law here, this hasn't been interpreted by the courts. That's a tool that we can use to kind of put out advisory opinions. They have the force of law until they're challenged in district court and overturned. Now, not every AG has that authority. That happens to be one that we have in Montana. But I mean, separation of powers is a thing. I mean, it's the judiciary jealously guards their sandbox just like I do mine. I didn't like it when I was a prosecutor, when I would have a judge try to call me and tell me how to prosecute a case. I'd tell him to go pound sand. You know, stay in your lane. This is my lane. You're over there in that lane. We have separation of powers for a reason. But I have found it very effective to be very, very vocal and very, very blunt and cynical in the media. I'm probably the first statewide official in Montana to tell people exactly what I think of our state Supreme Court and how terrible they are. And they don't like it. It is shocking to me how thin-skinned the judiciary is. They cannot stand this idea that the public find out that they are not Olympian entities and that, you know what, they are just flesh and blood people who use the toilet, and sometimes their opinions belong in there too.
So, yeah, I mean, in addition to Office of Attorney General opinions, which I think most of us have, I have that, and you've got that, George, as well. We also have amicus briefs. And one thing that's changed in Attorney General world over the last 20 years is that you have attorneys general, usually the Republicans all joining together on amicus brief, and sometimes, unfortunately, the Democrats do it too on theirs, where we weigh into cases that are in some far-flung jurisdiction that none of us, you know, Hawaii, for example, where we will weigh in and, you know, 20-plus Republican AGs will file an opinion, and that usually gets people's attention. It gets the U.S. Supreme Court's attention when we file an amicus brief. So, and that didn't happen so much 20 years ago. AGs suing the federal government because of agency abuse or overstepping statute. That didn't happen 20 years ago. So when we get together and file a brief, or even more so when we file a suit, it does make a difference, and we can inform courts what Bruin means, and we will keep doing so.
And we're getting asked more and more by our Supreme Court to weigh in on constitutional issues. So that's another piece.
But look at the interpretive methodology real quick. Just this is a legal nuance that I think is significant that we've all touched on, but I want to emphasize. The Second Amendment, when I talk about semantic originalism, the Second Amendment, we look at what did the rights mean, how were they understood by our founding fathers as reviewed through the prism of the ratifiers and adopters of the 14th Amendment. Now, juxtapose that with the way the 8th Amendment is interpreted. We all have to defend our State Department of Corrections who house prisoners. And the 8th Amendment is interpreted on an evolving standard of decency. So when California and New York say, well, this kind of toothpaste is cruel and unusual to those prisoners, we're all stuck with that. And so it's super important for us to weigh in on all these cases, remain vigilant, as Austin pointed out, on every single, you can't let up an inch or you'll end up with really bad case law. So the way we interpret the Second Amendment is correct, the way we interpret the Eighth Amendment is incorrect, and we need to reverse course on some of these other interpretive methodologies and get to what we're doing with the Second Amendment.
Gentlemen, this is probably our last question. I want to be respectful of your time. We're coming up on that hour alignment, so last question.
Thank you, gentlemen. Dan Cox, former governor nominee of Maryland, and I just had the privilege of beating on the issue of the ATF regulations for my client Machine Gun Nest. They were indicted with this fake Biden administration, Merrick Garland's law letter issue. And then now my other client has been attacked and sued by 2 AGs, but really by Bloomberg and Everytown, which has embedded themselves into the AG's office of the DC AG and Maryland, where I live. And they have now announced they're going to do this across about 16 states, I think, probably mostly blue states, I don't know. But we're fighting it. We're in the trenches. Any ideas of how we can expose this and stop Bloomberg and the Everytown movement from basically taking over through millions of dollars our own AG's office and trying to eradicate the beautiful gun stores that we have in Maryland?
Yeah, this isn't the first time that Bloomberg's done this. He did this with environmental justice folks that they were putting from NYU and some other places. Find a good conservative media outlet and expose it.
I would say another thing you could do is just drive 10 miles west.
You stole that from me.
We would be more than
Montana's
happy
lovely.
to invite you to the most Second Amendment friendly state in the country.
Second.
Might get a debate there.
We love a little tiny bit of Maryland.
Well, thank you, gentlemen, for spending your time with us. We really appreciate it. I think this was very insightful. And thank you for all that you do to help protect the Second Amendment.
It does look like.
Really, really appreciate it. So,
Oh, thank you, Larry.
big round
Thank you
of
all.
applause, everybody.
Appreciate it.
I don't think so.